So with that, I would like to introduce our next speaker, who is actually going to be with us on screen, and that is Mark Hasenauer. And Mark is with TD Wealth, and TD Wealth has a policy that doesn't allow them to go out and mix and mingle with all of us. So he is joining us, I believe, from Philadelphia, Mark?
Yes.
It's from Philadelphia, and I'd like to introduce Mark Hasenauer.
Pleasure. Yeah, so I wish I was there, but it's been now going on almost 2 years since we've been traveling anywhere, and I've been stuck here in the same office every day. One thing I realized, I put on a suit probably 3 times, and I'm realizing, so as I put this on today, my COVID weight has definitely caught up with me. So I'm lucky you're only seeing me from the chest up. So I want to give you this a little bit differently. As I'm listening to this, and I'm taking great notes, and the information, I'm going to talk to you like I would a client, right? So the conversation I have is everything you've had to date, or to up to now has been great information. It's that kind of college master's level, but oftentimes clients need to see the numbers very plainly in terms of what their goals are, and that's a more elementary conversation. And I found through my years of doing this, and a long time ago, I used to be a lawyer and an accountant, but I've worked for banks for a long time. So my job is to explain things in a way that everybody can understand them. And oftentimes when we're taking clients through the process, what really resonates with them is seeing how the actual numbers work. Sometimes we'll use Excel spreadsheets. If we're trying to show clients the ability to pay down a note and kind of isolate that, or how a GRAT or a series of GRATs are going to work. If they're going to reorganize and they want to see the cash flows. I mean, one of the great kind of the thoughts that just came up is you could use a higher note, interest rate on a note. So if you have clients who create 2 trusts and they're selling the business to Trust A, and that trust is for the benefit of the children who are going to own the trust. Doesn't have to be this way. This just came to my mind. And then Trust B, they gift the note, and that's going to get a market rate of interest. And ultimately, those proceeds might go for the non-interested, right, children in the business, right? That's a great strategy. But then also, a lot of times the clients have to make sure the numbers are going to work, right? What is it ultimately going to look like from year to year? What kind of stress does that put on the business, and things of that nature? So I am not going to give you any complicated spreadsheets today. What I'm going to show you is another part of the cash flow. And that's kind of just going back to maybe the basics with Naomi and Greg, and saying, are we going to be okay? Can we take care of our kids? And even a little bit of a side thought is, what about just Greg, right? And what if they split up? What if Naomi predeceases? How would Greg be able to make sure that he takes care of his goals separately from the 2 of them living together and having a great life? So if you wouldn't mind just putting up the first slide. I only have a few slides to take you through, but I'll talk a lot more than what's on the slides. All right, so anyway, we'll start out with their objectives, and we stated those before, but what is it that they're trying to solve for? And when we go through that analysis, hold on one second, please. They told us they want to maintain their lifestyle, want to provide for their children, minimize taxes, work towards a plan to simplify the family's financial situation, and overall to create a legacy that will continue beyond their lives. If you could go to the next slide. So those objectives are important because they're the basis for everything we're going to do, from cash flow planning to financial planning to business succession planning. But the question we did not know is what they were solving for in terms of financial goals, actual goals. So they want to provide for their children, but how much is enough? Greg wants his mother to have in-home care, but what is the cost, and do they intend to supplement her finances paying for it? Greg's son's Jason, he seems to be doing fine now, but what are Greg's goals for him, and what will that cost? Another question is, since Naomi has most of the funds, would Greg be okay for the retirement if something were to happen to Naomi or they were to split up? And what are Naomi's thoughts around providing for Greg if she predeceased him? Once we have the answers and hopefully numbers associated with those questions, we can start to build out scenarios based on them living their lives together and possibly even apart if that's at all a concern. So to help them plan for these goals, we build out a cash flow model that accounts for the assets they have now, the financial goals that they want to accomplish in the future, and then build out different scenarios of how that might play out. And with any cash flow retirement plan projections, you can break it down into a few basic factors. I'm sure people have different opinions on this, but from having done this for a number of years, you know what your starting assets are, right? The first question though is, how are you going to grow those assets by contribution and growth? The second is, what are the goals that you're going to eventually want those assets to fulfill, right? Is it an annual spending goal? Is it a legacy goal? Is it taking care of your heirs or charity or anything during life, right? There's something to be said. Someone said to me once, handing it off with a warm hand versus a cold hand, right? So is it all just legacy planning after death, or is there things that are going to take place during life, especially with grandchildren and later generations, right? Then what is the time horizon for the growth, right, on that? So if it's just a retirement conversation, where are they now? When do they expect to hit the retirement switch and begin drawing on those assets? And then finally, how long are those assets going to have to last during retirement? And if it's an age of 65, just to take an age to 95 or late 80s or into the hundreds, whatever it might be, what kind of stress are we going to put on those assets and for how long? So again, to go back to the Excel spreadsheet, it's definitely appropriated in some circumstances, and you can even take an Excel spreadsheet version of a retirement plan or a long-term cash flow plan. But the only problem with that is Excel spreadsheets create a straight line analysis. And when you're looking at rates of return as a substantial factor in how you grow your assets, we have to take into account market fluctuations. And that's a whole different conversation with standard deviation and how markets, our portfolios react in markets, and way beyond what I do in my function working for TD Bank. But where the financial software can make it a benefit or a difference is the use of a Monte Carlo analysis. And so we put all that information in the plan, but by adding the standard deviation based on Naomi and Greg's risk, we can then ask the question, if you were to live your lives 1,000 times over in varying market conditions, both good and bad, how many times would you be able to meet all of those goals? And it can provide a much more realistic predictor of if you're on the right track. Now, I'll stop for a second, and this is what I usually tell clients, is that when we were, I haven't seen everybody in the room, but I'm assuming we're all, probably in the same category as far as, what life was like when we were kids. And I remember, in the car with my parents, they pull out the map, right? And the map was intended to tell you, where we were going, the best route to get there. And what it did not tell you is detours. It's not like our phones now, right? It doesn't tell you what's coming up, right? So these plans are static in terms of, we can do the best job we can now with the information we have, but at some point we're gonna have to update this going forward. So even with adding standard deviation, even with the 1,000 market iterations, it does provide a better statistic based on a straight line. At some point, we're gonna still have to update the plan. So what do we know about them? As a couple, and they have an $18 million business, which is growing, $1 million in excess cash sitting inside the business, $4.5 million collectively in qualified plan assets and deferred comp, almost $1 million in cash and non-qualified investments, and then almost $5 million in equity and real estate. So that's depending on their spending goals, that's a pretty good situation to be in when you still have a few years left before you're ready to kind of turn on the retirement switch. And when we do these plans, we always want to kind of take a more conservative view. So even if the value of Naomi's business were to stay at 18 million, and I'm just, I'm making this up as, for purposes of a high level conversation. So let's assume taxes, broker fees, negotiating costs, things like that. She walks away with 10 million after the sale, right? Even in that situation, which is a pretty good situation to be in, they'd have plenty of money when you look at their other liquid assets, not even considering the fact that they have this real estate, which at some point they might say, this is more than we need. We're going to downsize, and we'll take additional funds and throw that into the pot as far as investments that we could use for our retirement. So when you look at the numbers just at a high level, and if there's time, I can kind of show you something live with regard to the numbers, but they could forget about the legacy for a second. They could spend $500,000 a year net of taxes, live into their mid 90s, and they would be fine without taking too much risk in terms of achieving investment returns. But the real question and the conversation that we end up having with the clients is, how much is enough? How much does Naomi want to leave her children? How much does Greg want to leave his children? And what happens if Greg and Naomi split up, or Naomi predeceases Greg and hasn't provided for him? So let's turn to Greg, right? Looking at the numbers for Greg, he has 2 million and roughly, I'm going to say pension assets, right? Deferred comp, 150,000 in savings, and a condo in Vermont worth 475. Assuming he's not saving much, if anything, from his own funds, right? He's kind of spending what he makes with his salary. We could still project out that he'd be okay in retirement as long as he kept his spending at around 140, 150,000 a year. Now, that's definitely a lot. It's a far way off from being able to spend $500,000 a year as a couple, but that's a conversation that we'd have with them in terms of playing out different scenarios and what they're trying to accomplish. So all of this will change, however, depending again on what they want to leave their children, and then whether they're going to build towards these goals through additional savings and or possibly purchasing more life insurance in terms of meeting their legacy goals. So based on this information, we begin our discussion, right, with the end result is what kind of lifestyle can they hope their assets to provide for them and their children, constructing an asset allocation for their liquid assets on the risk they're willing to take and the return they need to generate in order to meet their goals, and making sure that any estate plan will work with the goals they put in place for each other and their respective children. So I'll stop there if there's any questions. I can't see the audience. Otherwise, I'll kind of go forward. I can move forward and talk about what we do in terms of helping, and I would say any wealth management shop would do in terms of helping make sure that the plan continues to work, right? These are the things that we can do to help. A is periodically updating the plan. So any plan, no matter how sophisticated, again, is based on a static set of data at the time the results are generated. So we can twist it in 1,000 ways through the Monte Carlo analysis, but it will be wrong at some point if clients do not update it. Life happens, and that's just going to be a fact with any plan. The second thing is we can help clients determine their overall estate planning objectives, how their current plan lines up with objectives, and what options or strategies exist that are appropriate for them based on all we know. In the case of Naomi and Greg, we found out their objectives were to maintain financial security, protect and transfer the wealth primarily for their own children, right? And then create tax efficiencies where possible in order to create a lasting legacy. And then the third area, which we can go to the next slide, is we can offer the option to serve as a trustee or co-trustee and helping to administer any trusts that they create either during life or upon death. So with regard to using capabilities just in general of trust, right? I know we talked about this in greater detail, so this is just a kind of a high level summary, but they may choose at some point to form a trust in New York or Delaware to achieve their objectives. And basically, when you're thinking about trust, for the most part, they're a great way to carry out the family goals right? Carry them out, set your plan in motion and make sure that it, or at least hope that it's going to be met. Centralize the management of the assets, reduce the risk of funds passing to the children from being attacked by creditors or through divorce. And it can allow assets to grow while minimizing estate and GST taxes. When appropriate, a corporate trustee can add further value to the trust structure in ways where we add independence, continuity, right? You don't have to worry about your trustee getting sick or old. Can lend professional advice and have an understanding of the laws surrounding the administration of trusts. Now, with regard to Delaware, all I would comment on are basically two things. One is that where clients are looking for corporate trustees, from my experience, having done this for a number of years, they'll most likely find more options using a state like Delaware. Trust is going to hold an operating business and investment real estate. And the primary reason for that, to kind of follow up on what Lou said earlier, is that the Delaware trustee, and this is in general terms, can insulate itself from liability on the issue of whether the business or the investment real estate is an appropriate asset for the beneficiaries of the trust. In other states, that liability is very real for trustees. And it's all about having a direct trustee in Delaware. And the other potential benefit, which is a major benefit, is that for a Delaware trust, if it owns the business and that business is eventually sold and there's no Delaware resident beneficiaries, it could not be subject to state income tax. However, that always requires further analysis from the tax advisors. That's me. That's it.
All right. Thank you, Mark. That Ding Trust, and we're going to have time for some questions and answers. Beth, if you want to grab the microphone up here, we'll take some Q&A now, and then we're going to have a coffee break and stretch your legs a little bit, come back for the life insurance and the planning for the parents and the disabled son, and also the business valuation issues. But I'll take questions for Mark to start. Anybody have a question on the TD Wealth presentation or the asset management or Delaware trusts? Yes. We're going to get you the microphone for the people who are watching in their pajamas.
Hi, Mark. I guess my question to you is, how do you plan for unanticipated medical expenses as they age? Could be considerable costs. I know we're going to talk about insurance later, but other than long-term care insurance, is there some sort of, I don't know, formula used to kind of come up with a number that we should set aside for those unanticipated?
So this isn't going to be there's two answers to that. One is through, and again, a lot of this financial software is commercially licensed. So for instance, the one program I ran to kind of just high level look at the numbers for this, you can drop in an expense for long-term care and you can have it run for 3 or 4 years. When clients come and they sit with us and they're looking for a first round of advice when they're sitting with, kind of their financial advisors, what I've told them from experience is do a little research in terms of what you think you want and where you'll go if you're going to need care, because that level of care differs in so many different, it doesn't matter what state. I live down in South Jersey. The cost of care, if you're going to get it in one of these community homes outside of Atlantic City in the middle of the Pinelands versus you're up closer to Manhattan is going to vary greatly. So you should get an understanding of where you are from a care perspective, and then what you think your costs are, and then we could build that realistically into the plan. But there's that's a starting point. There is no set number in terms of what it would cost because it varies so greatly from area to area.
Thank you.
Other questions? Questions for any of our speakers? Yes. If you could get the mic, we'll have everyone here at home.
Yes, we have 97 people joining us virtually. So if that's helpful to know, the greater audience here.
in regard to the trust, the BDIT trust, can you just verify that you need to make the interest payments on the loan, whether it's at the AFR rate or whatever rate is in, but I just want to confirm that.
Yes,
Okay, thank you.
critical.
Because it's crucial, because I know I've been involved in situations where the interest payments were not made because everybody says, oh, it's just family, and it does get negated.
It does, and in this case, it's a huge loss if you ignore the sale, and it's going to bring the trust back into the estate of Naomi. When this bill, the business is 18 million in 2019, they're projecting this could be a 100, 200, 300 million dollar business. We're going to get all of that growth outside the estate, but it could boomerang back. It's an excellent point. It's also a point as to why you want a professional trustee, because the professional trustee is going to make that note payment. And they're going to assure that the clients are looking at this and calendaring it and diarying it every year to prepare for that cash, generate the cash, and make the note payment. And that's really one of the big advantages of having a Delaware trustee, because you can bifurcate the investment management from those kinds of administrative decisions and functions. And it is absolutely critical.
I think this is not working.
No.
I'm gonna add to that. I'm not sure this one
It's
is
working, yes.
Okay. All of these transactions really hinge upon them being bona fide business transactions. When we were dealing with the predecessor to this, the sale to the intentionally defective grantor trust, the bottom line is that if you're not selling for full value, you're giving something away. And with respect to the sale to the intentionally defective grantor trust, because the business owner is the one who's creating the trust and selling, if the trust is not paying full value and is not paying on the note, then you have a partial gift, and you end up bringing the entire business back into the estate because the grantor has now made a sale for less than adequate consideration. The same concepts, although not to the same extent, because the seller here is not the grantor, are going to apply here. I mean, the IRS is going to look at all of these transactions. I may be out of the IRS for a long time at this point, but I still have this part of my brain that still works like an IRS agent. When you're there, you're looking for anything that is going to make it not look like a bona fide sale. And so, yeah, it's so important.
And you have two risks. You have transaction risk, which the IRS will audit, and you have valuation risk, which the IRS will audit. So we're going to talk about the valuation risk in the second portion of the program and get into those issues and timing. When we were trying to get these plans out, when the Build Back Better Act was pending and all the grantor trusts were going to go away, but you could get grandfathered in, how do you make the gifts, do all the transactions, do the note sale, and still try to get a valuation at the point of time of transaction? It's impossible. So you have to backtrack. You have to do the gifts, do the transaction, and put things like wandery clauses in your documents, which will allow valuation adjustments if it comes back that you've gifted too much or too little. So it's tricky. Now that we have the benefit of time, we can wait for the valuation and do it with a full value and know exactly what it is that we're gifting and selling. But in many cases, we've had to do this over the years, 2012 and a whole series of other years where you had cliffs and pending changes in the law where you have to really draft carefully in the documents and coordinate very carefully with the valuation company in order to get that and get it right. Question here.
Yeah, hi. In the intentionally defective grantor trusts, when you would read the document, you'd be looking for that language, that paragraph about the power to replace the assets,
Yeah.
which creates that.
Something
Is there
between
something
671 and 678 of the code. There's a whole series of
Right.
grantor trust
Is
inclusionary
there
sections.
something specific in this trust that you're talking about now that has that same type of language that creates that?
What makes this well, you're not going to give the grantor any of those powers in the beat it, because we don't want this to be a grantor trust as to the grantor. We want it to be a grantor trust as to the beneficiary. So you give the beneficiary a 5 and 5 power over the initial contribution to the trust. So the grantor essentially has a general power of appointment over the $5,000 contribution. That in itself is going to make it a grantor trust to the beneficiary under 678.
Yeah, it's a good point. You draft SLATs, the spousal lifetime access trust, very differently than the beat it, because that's a first-party trust. And when we do a spousal lifetime access trust, we typically will use the power to exchange assets for assets of like value. That's very common because you want to have the flexibility, if you can, of over time taking highly appreciated assets and swapping them and getting them out of the trust and back into the estate to get the step up in basis. So that's a very useful power, not just for income tax purposes, but also for the reality of exchanging property later for basis step up purposes. Another question there? Okay.
In the sale of the asset to the trust, are ever sort of zero coupon notes utilized? And you could commercially justify, it's obviously zero coupon bonds out there, even government issued ones.
I have never personally used a zero coupon bond.
I can't hear.
So the question was, in selling assets into a grantor trust, what type of debt instrument can you use? And one of them is a zero coupon bond. Could you do that on a commercial basis and then translate it into a sale into an intentionally defective grantor trust? I had the same look in my mind that's on Karen's face. Never done it. It sounds very interesting, but it's not something that we've explored. Things like self-canceling installment notes are used, and you can value a skin and do this as a skin if that's preferred, in which case the note vanishes at the death of the seller. So there are a lot of options, and I don't know why it couldn't work. Any legitimate sale that looks commercial in nature, that has substance, as Karen said, it has to have substance, but if it does, it should work.
You touched on the possibility of setting up a new company for the son. A lot of this is about a sale of an existing company with value and valuation. But you didn't really go into much detail on what if it was a startup enterprise funded with nominal amount of money, but with the intention of having a material business relationship from the existing business, potentially even with a possibility of bringing in third-party investment into that business. But at the moment of startup, there's not much money in it at all.
So now you're talking about something I like a lot, which is a very stealthy plan. We call it an opportunity shift, where you take one very low value company, you gift it, and don't have a large tax exposure from a gift tax perspective, and you have another company that has value, that's been in existence for a long period of time, and over a period of years, you shift contracts, employees, opportunities from the valuable company to the startup company. It's a great plan. Getting clients to stick to the plan is hard because it takes time. You can't do it all at once because that's going to be a clear shift from one company to the other and probably an additional gift. But over time, I like to say at least 3 years, you can move those opportunities from one company to the other. Anthony's working on one of those right now on a sale to a beat it, and then an opportunity shift from there.
When we started working with this fact pattern, and I do a lot of work with intellectual property rights and planning with them. And this, we didn't have time to get into the presentation. But the fact of the matter is that this is an internet company which has a lot of IP rights. And so that there are a lot of other things that you can do, specifically by maybe separating out the intellectual property, put it into a separate LLC, and doing all kinds of other gifting or sale plans with respect to that also would shift different income streams and assets over to different people. You know, there's so much in this fact pattern that you can't really even all of us can't touch on it in 3.5 hours. But you know, these are things that require time, sitting with clients, sitting with a lot of experts, all of whom can pick out all these little potential opportunities that are out there for a couple like this.
Not to mention the marriage counselor, because we have an unlimited marital deduction that we're wasting here, where she could shift assets over to Greg, and Greg could then set up a spousal lifetime access trust back to Naomi if they got married. You also have the issue of the deceased spouse's unused exemption, the DSU, that could be used if they got married in Naomi's estate. So all of those things play in, and the family meetings are interesting. That's probably the most interesting part of this, when you get the couple to kind of open the kimono and show you what they're thinking, and then you get the kids in and get their perspectives on things, which are very often different than the parents ever expected. So those are fun meetings.
Yeah, and then we'll also add in, before we get to meeting, we'll also add in, when you have that discussion with them and you talk about the slats and the fact that once it's there, well, you know, if they decide that after they get married that it's not going to work out, how are you going to undo it? And whether or not Naomi is willing to, you know, transfer something over into Greg's column in view of the fact that, you know, having that marriage license and contract changes a lot of things. So
You sign the slat the same day. That's how you do it.
So, just something I was going to comment on it later, but we haven't touched yet on the conflict of interest issues here.
Oh.
Just keep in mind, everyone, we're talking about two unmarried people. If they were married, we'd still have conflict of interest issues with their planning. So all of this has to be looked at with the background of conflicts. And I don't even know if you can resolve all these conflicts. I mean, I just went through a plan where a couple had just got divorced, and I've been representing the wife, and the ex-husband wanted to retain me to do his planning. I spent 2 days trying to do a conflict of interest waiver, and I finally decided there's no way I can do this. So just keep in mind, as we talk all day long about Greg and Naomi and their planning, the conflict parts that are underlying all of this.
And
well, you'd have to have them sign, you know, when you sign the engagement letter, you're going to have to basically say to them that, you know, right now you're both on the same page. You may end up with differing estate plans that benefit one more than the other, but we have to share everything that you say. You know, everything Naomi says to me has to go back to Greg and vice versa. And if there is a conflict, there may come a point when we have to step away and you both have to go see separate lawyers. I mean, that's included in every engagement letter that we're doing for not just married couples or unmarried couples, but anytime you have two people walking in to do an estate plan together.
Absolutely. And this is what our attorneys' meetings are like now. It's hard to get the last word. But with that, we're going to take a short break.
Just one quick comment, if I may add, Lou. This last gentleman, the point about conflict of interest, brought into my head the other reality we have not discussed at all here, which is future generations. Mm-hmm. Just making it intractable almost, but just that is another challenge, is balancing across those generations, not just the kids and the parents, but grandkids and beyond, particularly if the business grows to a magnitude where it can continue to provide support 50 years in the future.
It's a great point, and it's a reason to have a trust protector in the trust. Because if you're using intergenerational and multi-generational trusts and your third, fourth, fifth generations, things are going to look a lot different. And a trust protector can be given powers to modify the plan, modify the trust, and adjust things at a future date. And that, we think, is an extremely potent and powerful provision that we can incorporate. Delaware has a tremendous trust protector statute. It gives indemnity to the trust protector. And our firm doesn't serve as trust protector, but we put ourselves in a document typically so that if the need arises, we appoint an independent trust protector at the time. So we would look and choose the right person and put them in as trust protector to serve on behalf of that client. With that, I want to get you coffee and a chance to stretch your legs. I want to remind everyone that the materials for those of you online are at purolaw.com resources. You have the slides and the full fact pattern here live in your handouts. Networking for the next 15 minutes. We will have some more Q&A at the end of the program, so bring your questions back. Thank you.